There's a High Court case reported there in the newspapers today where a judge has ordered a farmer to remove a milking parlour he built without planning permission by September the 19th. So the parlour has to go by September the 19th. It's an unauthorised development. It's been rejected over concerns about nitrates and potential traffic hazard. The gentleman involved, Patrick Furlong, he must cease milking operations by July 21st, and in the meantime his herd must be moved to another farm with a lawful milking facility, ruled the High Court judge. Mr. Furlong built the parlour and associated works, including slurry storage and parlour washing tanks, at his farm in County Wexford in 2020. It had been a dry stock farm before this. Wexford County Council served warning enforcement notices in 2020 requiring him to cease the unauthorised development and restore the lands to their previous condition. He then made a retention application, but it was refused on grounds including that he had not demonstrated that there was sufficient effluent storage capacity on the site, and it was not clear that the development would comply with the Nitrates Directive, which is aimed at protecting water from pollution from agricultural sources. Wexford County Council also refused it on the grounds that the entrance created a traffic hazard on a county road and would be contrary to the proper planning and sustainable development of the area. And then several retention applications and appeals followed. Mr. Furlong then brought High Court judicial review proceedings over the decision 13 months ago, but these are still pending. So meantime, enforcement proceedings were brought in the Circuit Court in April last year. They ordered the cessation of the unauthorised development and reinstatement of the lands. The court placed a stay of 12 months on the order. Mr. Furlong then appealed this decision to the High Court, which dismissed the appeal this week. The judge said it would be inappropriate to put a stay on the orders to allow Mr. Furlong an opportunity to make what would be a fourth attempt to obtain a form of retrospective development consent through what is known as substitute consent. With respect, the judge said no developer is entitled to this level of indulgence, and this is a clear-cut case of unauthorised development. The unauthorised structures and reinstatement of the lands is to be carried out by midnight on September 19th, the judge said. So often you'll see these cases where there are unauthorised developments. They invariably end up in the High Court with enforcement orders being sought by the local authority, by the County Council, to have their planning decision enforced and basically the removal of the unauthorised development. This particular unauthorised development, the milking parlour for Mr. Furlong there in Wexford, is going to be a very expensive sort of a process because, let's face it, he's probably spent a good bit of money developing the milking parlour and associated works, and then he has been involved in a legal battle since 2020 with Wexford County Council. Now the legal battle alone from 2020 with Wexford County Council is going to have cost him a right few bob probably, and going to the High Court then for a judicial review, that is an expensive process. So if there's one lesson here for anybody thinking about carrying out an unauthorised development, you really do have to be very, very careful, because if you don't get the retention permission, then you're taking a big gamble and a potentially costly gamble. Hope you find the video useful. If you do, I'd appreciate if you gave it the thumbs up down below. Thanks a lot.